Welcome back to this course on copyright and related rights law. This week we are looking to discuss performer rights. In the title of this course, which reads Copyright and Related Rights Law, performers' rights we have understood falls within related rights. We have understood the difference between a work and a performance, where there is a pre-existing work which has a copyright in it. The performance of such a work would have to be authorized by the copyright holder. In today's session, we are going to discuss what are the economic rights that are granted by the Copyright Act to performers. But before we look at these economic rights, we must understand the background to performer rights. Performances as creative expressions were not considered in the original international agreement on uniformity among countries with respect to copyright, also called as the Berne Convention. The Berne Convention, which is an international instrument which came in the 1880s and which has undergone several revisions, is concerned with literary and artistic works. In other words, subject matters what we have discussed under copyright. Performers and performances have later been understood as subject matters of intellectual property, and because of their similarity to expressions which are considered as subject matters of copyright, because of the creativity which is attached to such performances, they have found their place within the international copyright universe. And therefore, even though copyright protection has been around in many countries since the late 1800s, performers' rights have come much later. In fact, this particular initiation of performer rights could be attributed to a movement which started with the 1961 Rome Convention. In any case, if we consider a specific jurisdiction, such as the jurisdiction we are considering, India, in India, it was only in 1994 that performer rights were introduced for the first time. Prior to 1994, the Copyright Act effectively extended protections to subject matters such as the ones we have discussed. That is, literary, artistic, dramatic, musical, cinematograph and sound recordings. Another element that we will discuss under related rights, that is broadcasting, deserves its own discussion and something that we will take up in the future sessions after we discuss performer rights. Let us then, in understanding the economic rights of performers, look back once again to Section 14 of the Indian Copyright Act. We have seen that copyright is defined as an exclusive right to do or authorize the doing of any acts which are prescribed under 14, and one such act that Section 14 prescribes is performance of the work in public. We have understood that performances of works which have copyright in it require the copyright holder's authorization. The content of the performance in such a case is not of the performers. Could it be of the performers? It could be. But in a situation where it is not, then any such performer has to be careful about taking the requisite permission. Let us also understand a fundamental understanding. How many performances can there be of one work? Let us see what section 14 is saying. Section 14 is saying that if a performance of the work must happen, then such a performance must be authorized. What does that tell us? What if the work is a musical work? Is there a limitation on how many performances there can be of that musical work? I'm sure, as you must be realizing, there can be infinite number of performances based on a single work. Therefore, the importance of the copyrighted work is very much when we consider performances. Each performance which is going to have its own distinctive trait, its own uniqueness, is going to present that work in a slightly different manner than it has been presented by another performer. But that does not take away the fact that a performance right towards such performances which a copyright holder has can be licensed to an infinite number of performers. But the fact that a performance right has been authorized and a performance has been made, what right does the performer who has performed have on that specific performance? I hope you're getting this. Let me repeat. If there are 100 performances of a single work, which is a musical work, then each of these 100 performers can exercise performer rights over their individual performance, though the work is the same. And these rights which the performer will exercise over his performance is what we are referring to as performer rights. To which now we will look at section 38A, which provides for the economic rights with respect to performers. It's called as the exclusive right of performers, that's the title, and the provision reads, without prejudice to the rights conferred on authors, the performer's right, which is an exclusive right subject to the provisions of this act to do or authorize for doing any of the following acts in respect of the performance or any substantial part thereof, namely, in section 38A, we have already seen that the provision has been drafted in a manner that performers' rights cannot be prejudicial to rights of authors, which means that if there is a copyrighted work which is being performed, then there is no way that such a performance can happen without authorization of the copyright holder. Now, there could be exceptions to the general norm of authorizations, but exceptions are something which we will discuss later when we discuss exceptions in terms of section 52 of the Copyright Act and the general understanding of exceptions to copyright internationally. For now, let us focus on economic rights of performers. And as we can see under section 38A, section 38A provides certain types of rights. And what we will do is take a look at each of these rights individually so as to understand them best. The first right we are going to take a look at talks about the right of the performer to do or authorize the doing. Making a visual recording, you must understand, is an act of fixation. The live presentation, the live visual presentation that we have understood constitutes a performance under section 2Q, the fixation of that live performance in a visual medium is something that the performer can authorize. Why is this important? You might realize that performances which happen live, for example in concerts, the recording of such a concert performance is something that, according to this provision, a performer can authorize. You would be thinking, but the audience present in such concerts are recording the performance. What about them? Is the performer going to stop them? Like I said, certain types of usage and certain types of acts can be considered as exceptions to performer rights. For example, an act which is being done primarily for personal use is something that will not affect the commercial nature of such performer rights. And this understanding of exceptions is something that we will look at in future sessions. For now, let us understand that because we are discussing economic rights, let us try and figure that the acts which can have some kind of an economic harm to the performer would be something which the performer would be incentivized to prevent from happening. And this incentive is in the form of an exclusive right. This particular exclusive right, which we have discussed, is making of a visual recording, or in other words, fixating the live performance, which is a visual presentation, in a visual recording. Now, visual recording is only one kind of fixation possible of a performance. What we have seen in section 2Q is that a performance is a visual or acoustic presentation. Acoustic refers to sound. So not only can a live presentation be fixated through a visual recording, but it can also be fixated through a sound recording. Therefore, this provision states that fixation in the form of a sound recording is also something that the performer can authorize. With respect to these recordings, the kind of utilization of these recordings is a separate control which vests with performers. Please understand, what we have discussed at this point is simply the act of fixation. The recording has happened, but utilization of that recording, how will that recording be utilized? That is something which is within further control of the performer. Let us look at the first of such further control. It says, reproduction of it in any material form, including the storing of it in any medium by electronic or any other means. Where this recording has happened, its reproduction in a specific material form, such as you can see in the form of a cassette. Such a reproduction of that recording is something that the performer can authorize. As you can understand, there can be reproduction in many such material forms, including, as has been stated within this provision, even storing in a medium by electronic means is also something that will be considered as reproduction. Therefore, reproduction and just the act of reproduction. There can be utilization of these reproductions. That is another application of performer rights. But just reproduction is something that performers can control. The second kind of control of such recordings is issuance of copies of the recording to the public, not being copies already in circulation. Issuance of copies is a reference to distribution of the reproductions. And you would realize that distributions where they are happening, because distributions are connected to geography, this can be something which has a lot of potential for commercial utilization for creators such as performers. And therefore, this is something which is a separate set of exclusive right which is granted to performers. You will note a very important phrase that is used in this particular provision, which is not being copies already in circulation. What this means is that a performer who has an exclusive right to control distribution only has that exclusive right till the point of first sale. Once a unit, say for example, consider a cassette, once a cassette has been sold, then the further sale of that cassette is not something the performer can control, because now that particular unit has entered circulation. This is what this provision is saying. In other words, the control over issuance of copies is lost the moment a sale of this unit occurs. Okay. Illustratively, let's understand this. Supposing I am a performer, my cassette, the recording of my sound on a cassette is bought by you. There will be, say, 1,000 of such cassettes. One is bought by you, for which there has been a valuable consideration. Now, because I have received this valuable consideration, I cannot now control the further distribution of the unit purchased by you. If you were to go ahead and sell it yourself, then that is not something I can stop. But what this also means is that this particular limitation is only applicable to distribution or issuance of copies specifically. It will not include reproduction. Just because you have bought this unit doesn't mean that you can create more units from that unit. The limitation is only with respect to further distribution. The third kind of control is communication of the recording to the public. Now, what we have seen in terms of issuance of copies is that we were referring to physical copies. But especially over the last decade, we have seen with the improvement of technology and with the mass availability of smartphones, the rise of broadcasting, we have been able to hear new releases of sound recordings through the help of our smartphone without purchasing any cassette. This kind of communication is referred to as communication to the public. And communication to the public is a separate exclusive right, separate from issuance of copies. The fourth type of control you can see is selling or giving it on commercial rental or offer for sale of a commercial rental any copy of the recording. What this is a reference to is that the presence of libraries, the presence of video libraries or cassette libraries, which are engaged in the business of providing these copies, such as for lending and renting, then because a specific unit is being used again and again, repeatedly, it is capable of generating a higher amount of revenue. And this kind of usage is also something which a performer can control. Let us now come to another right. What we discussed in the first phase of our discussion was the fixation of the live performance and dealing with that fixation. The second right is about broadcasting of that performance, broadcasting or communicating of the performance, except where the performance is already broadcast. How is this different from what we discussed earlier? In the earlier discussion, what was being communicated was the recording. In this particular right, we are discussing communication of the live performance. Where communication of the live performance is happening, that is different from a fixated communication. That specific control is what is governed under this right. And you can see it makes an exception by saying, except where the performance is already broadcast. In saying so, it is bringing in the consideration of broadcaster's right, another type of related rights, wherein the question will be whether a performer can control any rebroadcast of the broadcast. As we will understand in the later sessions of this course when we discuss broadcasters' rights, that rebroadcasts are broadcasters' exclusive rights. But the initial performance communication, the live performance communication, is something that the performer controls. Let us now come to another segment of 38A, which talks about incorporation of performances in cinematograph films. Now, this is something which all of us have seen, that films are incomplete without performers. But what kind of control do performers have over such performances in the cinematograph film? What this provision says is that once a performer has, by written agreement, consented to the incorporation of his performance in a cinematograph film, he shall not, in the absence of any contract to the contrary, object to the enjoyment by the producer of the film of the performer's right in the same film. What this means is that once the performance is incorporated in a film with the consent of the performer and through a written agreement, then the performer's rights we have discussed, those performers' rights will now be carried forward by the producer. And therefore, the rights which we had discussed, they will not be used by the performer to create some kind of an obstruction in the communication of the film by the film producer. Now, there is an important provision which is attached to this particular provision, and which is, notwithstanding anything contained in this subsection, the performer shall be entitled for royalties in case of making of the performances for commercial use. What does this mean? If we look to the Copyright Rules 2013, under Rule 68, Explanation 2, commercial use is defined. It says, commercial use as mentioned in the proviso, which we just read, means the exploitation of performer's right by way of reproduction, issue of copies or distribution, communication to public, including broadcasting and commercial rental of the cinematograph film. What this provision is saying is that while the rights that are provided under 38A1, which we had discussed, reproduction right, issuance of copies, communication of performance, while these rights cannot be used by the performer to create an obstruction for the film, the revenue that is being generated by such use of the performance, from that revenue, a certain royalty must come to the performer. This is what this particular provision is saying. And you can see the wording is, shall be entitled for royalties. And therefore, this is a mandatory form of payment that must occur with respect to performers. Having understood economic rights of performers, in the next session, we are going to take a look at what are the performers' moral rights. And with that, we will touch on a very important facet of copyrights, which is that the copyright law not just only serves the economic interest of the creator, but rather also some of his more natural interest, that is, with respect to acknowledgement and any kind of damage to such work. How does this play out with respect to performances? This is something which we will look in the next session. Thank you for joining me. See you all in the next session. Thank you.